Grant,
Thank you very much, Mr Chair. And I think that excellent contribution from Jacinda Ardern, it does give us pause for thought about some of the facts that we need to lay on the table. And the first of those is around what Mr Quinn, and he's now blamed it on the Parliamentary Council Office. He did. He blamed it on PCO. He did, and what we just need to clarify exactly what happened there. And I think the whole House, and indeed New Zealand, owes a debt of gratitude to Associate Professor Andrew Geddes from the law school at Otago University, because it was him who, yes, he was my former flatmate, that is true as well. He was the person who drew the attention to the fact that by repealing the current disqualification provision that's in the Electoral Act, section 81(1)(d), and replacing it with a new provision, quote, a person who is detained in a prison pursuant to a sentence of imprisonment imposed after the commencement of this bill, that actually meant that Clayton Weatherston, Graham Burton, William Bell were all going to be able to vote.
So what
that was what it meant.
What's the debt of gratitude that we've got?
Well, true. The debt of gratitude for us in the long term is that this has been pointed out. The problem is that Paul Quinn has come back today and as Jacinda Ardern said, he's actually proved a point and a fact that's important to lay on the table. That is that most people in prison do not get to vote in New Zealand. What this bill is about, and what this Mr Quinn has failed to do, is come to the House and explain to us why the status quo, the law as it is now, should be changed. Because as it stands now, serious criminal offenders do not have the ability to vote. Those who are serving terms of less than 3 years, and of course those people have committed crimes, and of course they deserve to be in prison if they are there. But the question that Mr Quinn has not answered is that every single one of those people will be back in society. And at that point we have to ask ourselves, what is the purpose being served by this bill? Because if we want people to be able to reintegrate into society, if we want people to be able to contribute constructively, then why would we take away their ability to be part of that society and to vote? And in the contribution I was making before, Mr Chair, when I was interrupted, I was talking at that point about defending democracy when it challenges us. And this is a situation when it is challenging. As Jacinda Ardern had said, it's a difficult argument to make. But the fact of the matter is that if we aren't prepared to defend democracy and the rights of people who challenge us by their actions, what kinds of democrats are we? That's the very point at which, as a House of Parliament, we need to stand up and think very carefully about whether we want to take away some of those fundamental rights. And that's obviously why the Attorney-General brought forward the Bill of Rights opinion that he did, the report that he did. And I mentioned before the concerns raised about Section 12. But I was interested by one of the comments in Mr Finlayson's report. He said, Bill of Rights inconsistencies are justified where the provision serves an important and significant objective and where there is a rational and proportionate connection between the provision and the said objective. And that's the problem with this bill, Mr Chair. There's nothing wrong in the end with having a justifiable inconsistency with the Bill of Rights. But what the Select Committee's analysis of this bill, what the submission-making process in this bill has shown, is that there isn't an important and significant objective here that will outweigh breaching those bits of the Bill of Rights. And there isn't a rational and proportionate connection between the provision and the said objective. Mr Finlayson's report goes on to say the stated objective of this bill is to disenfranchise the most serious offenders. The most serious offenders. The point here is the most serious offenders are already not able to vote. So Mr Quinn's bill doesn't meet that test of whether or not we should compromise those hard-won rights that people have. This is not about whether or not people are being punished sufficiently by being in prison. Those who are in prison have lost their liberty, Mr Chair. And at that point, particularly, and I admit the 3-year thing is a fairly arbitrary number, but particularly when we know those people are going to return to society, what is our goal? Our goal surely is to find a way to help those people reintegrate into society, rehabilitate. And unfortunately, this bill does nothing to assist that, Mr Chair.
The Honourable Leanne Dalzell.